On this week's 51%, we sit down with Columbia Law School professor emerita Jane Spinak to talk about her controversial book, The End of Family Court, and how abolishing the family court system may bring better justice to women, children, and families.
I think if we shrink this system, then it is much more likely that parents and children will get their due process rights.
I'm Jesse King. It's all up next on 51%.
I was standing around like one of those girls I had seen in a movie. The whole world was a movie back then. I had my sunglasses on, I wanted to be seen without seeing shy Lolita. I wasn't really in it, I didn't really get it.
You're listening to 51%, a WAMC production dedicated to women's issues and experiences. Thanks for tuning in. I'm Jesse King. Last week, we heard from women who successfully battled addiction, often after years of recovery work and turmoil in their personal lives. Some of the women we heard from even faced separation from their children, or at least the threat of separation. Now, those were pretty extreme cases, but as our guest today will tell us, reports to Child Protective Services are, in general, more common than you might think, and it's a possibility that some families live in fear of. Jane Spinak is the Edward Ross Aronow Clinical Professor of Law Emerita at Columbia Law School. For more than 40 years, she has worked in the realms of juvenile justice, child advocacy, and family court reform, exploring the ways in which we might better the court. Most recently, she directed the Adolescent Representation Clinic, helping teenagers and young adults aging out of foster care. Spinak says she's been so involved with the system for the majority of her career that she was surprised to discover that when she started writing about its effectiveness, she came to the conclusion that the system was too broken to be fixed and ought to be thrown out altogether. It's a viewpoint that some might see as pretty radical. But in The End of Family Court, How Abolishing the Court Brings Justice to Children and Families, Spinak makes the case that the current child welfare system is largely entwined with racism, a disdain for poverty, and an assimilationist approach to fixing families that are different. By shifting some responsibilities out of the court's sphere, Spinak says we can provide more meaningful solutions to families in need, reduce the number of families that are split up, and better address cases of child abuse and neglect.
The original juvenile court, what I call the great idea, was that a judge, a benevolent judge, a judge that was focused on treatment rather than punishment, and a probation officer or a social worker would identify a young person getting in trouble or identify a family that they were concerned about and try to fix them. That's not what courts usually do. Courts are places where you make legal decisions, but this court was considered a social court, and that means that the court was given incredible discretion to decide how to so-called fix families. It started at the beginning of the 20th century when there was enormous amount of immigration coming from Eastern and Central Europe. These immigrants were especially impoverished. They were fleeing from those areas in Europe, and they were different than the earlier settlers in the country. They had different cultures, different languages, different skin tone, different ways of doing things. And many of the so-called progressive reformers at the beginning of the 20th century wanted to turn these immigrants into what they thought were proper Americans. And so one of the ways that they identified doing this was to create this social court where if a young person was in trouble, they would be taken there and the judge would kind of figure out what to do. The positive aspect of this was the identification that children should be treated differently than adults when they get into trouble or commit a crime. And we should hold on to that. We don't want to treat children as adults. Part of my argument is you don't need a separate court for that. You just need laws that are clear about how children are different. But the other part of the court's basis was to fix families who were different and to mold them really into something that looked more like the American settlers who were already here. This court, interestingly, was created in large part by women who got together in women's clubs, for example, in Chicago, where the first court was, to both urge the legislature and the city government to do this, but then also to figure out how this court should work. And that history of women being involved as volunteers in the court has continued to this day. And sometimes the work they've done has been very positive and sometimes not so positive.
So when we look at the state of the court today, what impact is that having on families?
Well, it's having a great impact. Unfortunately, the largest impact is in the child welfare system, or what I now call the family regulation system, where we bring hundreds of thousands of families into family court every year, and we charge them with neglecting or abusing their children. In fact, the largest number of families, both that are investigated, but those that eventually reach court, the largest number are there because of some aspect of neglect that is closely aligned with these families being poor and not having the resources to care for their children in the way that they want to. The public often thinks that this court is mostly dealing in abuse because that's when the court tends to be covered by the media, when some terrible tragedy happens to a child. But in fact, between 20 and 25% of the cases deal with serious physical, sexual, or abuse, or some form of neglect that is extreme, like starvation. The vast numbers, over 75%, are really about poverty and related issues like the lack of substance use treatment in the community, like the lack of childcare in the community, the inequalities that we have yet to solve around schooling, healthcare, mental health care, childcare. And so families are brought into court for these reasons, but they rarely then result in families getting these services. And in fact, too often, instead, the family is destroyed. Children are taken temporarily from their families, and often this results in families being permanently separated. So termination of parental rights, and children spending most of their childhood in foster care or being adopted by someone else, which is a mixed bag, as we're learning from some of the most recent stories that are in the headlines. Both the newest story about what happened in The Blind Side, but also the story of the parents who had adopted, the white women who had adopted multiple numbers of Black children and then drove off the cliff with them. Those are horrific stories, but they are indicative that adoption is not a simple solution, and that we have to think about, do we really want to be separating families who are mostly in court because they don't have the resources that they need?
You mentioned before our conversation here that you've done a lot of work representing children facing status offenses, and you talk about it at length in the book, too. Before that, I wasn't really aware what status offenses were. For those who don't know, can you explain what a status offense is and why are they still a thing?
Well, my first recommendation in my book is to abolish any jurisdiction over status offenses. They are cases where a young person gets into trouble but doesn't break the law, but they can be brought to court anyway. So things like running away from home, having underage sex or drinking, being truant, these are all acts which are not criminal for an adult, but a young person can be brought to court for them. So essentially for misbehaving. When the court was originally founded, those cases were part of delinquency. And then later in the 20th century, they were divided into two different categories. This has always been part of wanting to control girls and young women. I have a great quote that goes along with an illustration that comes from the Mid-Hudson Training School, which is now I think a minimum security prison in the Mid-Hudson. But for a very long time, it was a reform school for girls. And one of the matrons said, "Our chief task and aim with delinquent girls is to protect them from the natural consequences of being girls." So status offenses are trying to control young people so that they don't do things that adults don't approve of. I think it's important to recognize that these are mostly young women who are surveyed by law enforcement, by schools, by communities that tend to be especially investigated by law enforcement in schools, but also it can be that parents who don't have resources turn to the court because they don't know what else to do. And then they discover that what the court does in either offering treatment or supervision or taking their child away from them has not resulted in their child being better off. And this has been true throughout the history of the court. I think it's also important, just like you said, gee, I didn't know about this. Only some young people are taken to court. And I'm guessing that you misbehaved as an adolescent. I misbehaved as an adolescent, but we didn't end up in the family court. And as one judge of the family court who actually has worked on changing how status offenses are dealt with said, I got into a lot of trouble as a young person, but I didn't get arrested. I didn't get taken to court. And now I'm a judge. So there's a real inequality between who gets taken to court and who doesn't. And even today, the young people who get taken to court for status offenses are disproportionately impoverished and disproportionately young people of color.
Now, you're arguing that we should just do away with family court, that it's too broken, and past attempts to reform it have been unsuccessful. What are some of those past attempts? What have we already tried here in your eyes?
Most of the reforms in the past are really about putting more money and more judges into the court after there's been a crisis. Ironically, throughout the whole history of the court, there have been a series of reports, not by people who are particularly radical, but rather by government bodies, presidential commissions, U.S. advisory task forces that have said, you know, this court is not working in the way we thought it should. And we should be thinking about what can we take out of the court? How can we change it from being this so-called social court into being a court that is more traditionally a legal court? Or how can, as I'm recommending, we abolish it entirely, get rid of this idea that the court can do good, and for the small number of cases that need to be in court, put them into traditional common law courts, civil courts, criminal courts, to deal with a much smaller number of cases that need to be there. I'm not suggesting that our overall court system works well, because it doesn't. But you will always need some court system to deal with the most serious cases. My overall recommendation, which is the recommendation that has happened every decade of this court, someone or some task force or some commission has made this recommendation, to take as much out of the court as possible, shrink the court's jurisdiction. And for those issues that are really social problems, not legal problems, put the resources into the community rather than trying to put them in court or trying to put them in government agencies that work with the court. For example, in status offenses, is to recognize that if we had the services that some young people need in the community, we wouldn't have to go through a court system. So we don't have enough mental health services in our communities. We don't have enough substance use services. We don't have enough recreational programs. We don't have enough schools who are well funded and can address some of the issues that get young people into trouble, but not breaking the law. That's one example. In the family regulation system, we spend, at last count, $15 billion for out-of-home care for children who are part of the child welfare family regulation system. If we put $15 billion into the community and said, let's figure out with the community what would help you take care of your children well, that would go a long way to reducing the number of children that ever have to be taken away from their parents. I also want to comment about our system overall. We now have a child abuse and neglect reporting system that will report by the time they're 18 years old, 1 in 3 children in this country, and 1 in 2 Black children. This system, at last count, reported on almost 8 million children. So they were surveyed, they were investigated, they were interrogated, even though through this process, only about 500,000 children a year will be petitioned into the court. So all of these families have been disrupted. Most of them have not gotten services after they've been reported, but they have come under a lot of scrutiny that has made them very reluctant to reach out to professionals who might be able to help them for fear of being reported. And we have a system that in which almost everybody is what's called a mandated reporter, which is just about any professional who deals with children. In the 1990s, the U.S. Advisory Board on Abuse and Neglect said, we need to stop this reporting system. It is not working. It is not keeping children safe. What it is doing is disrupting families and not providing them the services they actually need. And what we need to do is provide neighborhood-based and neighborhood-developed supports for families. And yet we didn't listen to that advisory board. And instead we kept expanding the number of children who might be reported. And unlike what the public commonly believes, which is that if you report to Child Protective Services, families are going to get assistance. In fact, they're not, for the most part, going to get assistance. Also, teachers are the professionals who most often report children that they are concerned about, either because they actually believe the child is in danger or because they've been told, if you are worried about anything related to this child, just make a report. Well, teachers' reports are the least sustained. They are the ones that are most likely to be screened out after an investigation, because most of those reports are not serious. They've been taught they have to report. And what they don't realize is that the families they're reporting almost never end up ultimately going to court and almost never end up getting the services that the teachers think they're going to get.
We've been speaking with lawyer and former Columbia Law School professor Jane Spinak, author of The End of Family Court. What impact do you see this having on children specifically? I know you mentioned that this makes parents less likely to reach out for the support that they need for the fear of separation, but what impact does separation specifically have on kids?
Well, we know more and more that the trauma of removing children from their families is as great, if not greater, than the neglect that they may be experiencing at home. Again, I'm not talking about the most extreme cases where, of course, you at least want to temporarily remove that child to figure out, can that child be safe at home? But as I said earlier, that's not what most of this system is about. And what we have discovered, what social scientists have discovered, is when you compare children who are at risk of going into foster care, but stay at home, with the same children who are at risk for similar issues and have similar demographics, who go into foster care, their long-term outcomes are worse than the children who were left at home. So we know that the system is not working for the vast majority of the children. And I've represented children over the course of my career, and I've represented parents over the course of my career. I have rarely represented a young person, a child or an adolescent who isn't traumatized by being taken from their families, who isn't traumatized by being in foster care, because many children just bounce around in foster care and they have terrible outcomes in terms of finishing school, their health issues, their job prospects. Ironically, many of them who age out of care go back to their birth families because they don't know where else to go. And sometimes that's great because their birth families are able to take care of them again or be connected with them. But if their families had gotten the support before they were removed, they could have grown up with them and likely have a much better outcome than being in foster care. Also, I think it's very important for the public to know that about 20,000 young people age out of foster care every year who do not have family and whose legal rights to their parents have been terminated. So they age out with neither an adoptive family or a birth family, and they often have nowhere where they feel like they are supported. And as we know, you turn 18 or you turn 21, it doesn't make you an adult. We know now that it takes a lot longer for all of us to get through our 20s and into a stable adulthood. But these young people often don't have anybody who's helping them do that.
So if this were to actually happen, when it comes to ending the court, how do you recommend that we do that? I have to imagine that there would need to be some kind of like step-by-step process or rollout here, because otherwise, if you just like end it straight up, it's going to be chaos.
There is a process. Abolitionists call them non-reformist reforms, which means what are reforms that can shrink the system, moving toward abolition rather than strengthening the system. So eliminating status offense jurisdiction is an obvious one. Another is the international standard for juvenile responsibility in delinquency is 14. In most states in this country, there's not a lower limit. So we could bring in, and we do bring in, very young children, 7, 8, 9, 10, who are being held responsible for acts that they don't even understand. So raising the minimum age to 14 and providing all those other children with the help they need in the community is another example of a non-reformist reform. Eliminating the mandated reporting that I talked about earlier would make a huge difference in who ultimately ends up having to be brought to court. And then the most important reforms are really the reforms that would go on outside of court, supporting families in their communities, allowing families to help create the solutions would ultimately mean that many fewer children or families would ever find themselves in court. And then the court system could say, well, we really don't need this court. We might need a part of the civil court to focus on these issues. We might need a part of the criminal court to focus on these issues, but we don't need a whole court. If families or children are brought to court, the other important reform is making sure they all have their due process rights, which currently also is not true. Children and families across the country are not being represented in court well or at all, even though for young people, they have a constitutional right to have a lawyer. In many jurisdictions, they don't get a lawyer. So I think if we shrink this system, then it is much more likely that parents and children will get their due process rights.
Jane Spinak is Professor Emerita of Law at Columbia Law School. Jane, I'm afraid that's all the time we have today. But Jane's book is The End of Family Court, How Abolishing the Court Brings Justice to Children and Families. It's out now through NYU Press, and you can find it at most major booksellers. Jane, thanks so much for coming on and speaking with me today.
I enjoyed talking with you very much.
You've been listening to 51%. 51% is a national production of WAMC Northeast Public Radio in Albany, New York. It's produced and hosted by me, Jesse King. Our associate producer is Jody Cowan, and our theme is Lolita by the Albany-based artist Girl Blue. Just a reminder that you can listen to 51% anytime at WAMCpodcast.org or wherever you get your podcasts. And you can stay in the loop on all of WAMC's shows by signing up for our weekly newsletter, Airwaves, at WAMC.org. We hope you'll join us next week. Until then, I'm Jesse King, 51%.
I was every single girl, I was nobody else, I was so sure of myself. I was 15 and a half, he was a hollow laugh. And I lost my cool somewhere along the way. The night that down the hallway. I had to learn how to look away. I lost my cool.